Today we have a great session for you planned on dealing with difficult owners and talking about a COVID-19 update. So as people start to join this call, I'm going to just kind of start with some warm-up comments because it does take a little while for people to join and log in. Well, first, I just want to say it's wonderful to be with all of you today, even though I can't see you in person. It's nice to at least be able to connect via a live Facebook Live today. And it's fun that I can see a lot of clients that are joining and people that are regular followers of our Facebook Live. So great to see Rick Marine here and a number of other people. So I always like to know who's in my audience, whether I'm teaching a live seminar or whether I'm doing a Facebook Live. And so if you wouldn't mind letting me know where you're joining us from today and your association's name, that would be wonderful so that we can get a good read on who's listening to us. And if you're back in Wisconsin, Michigan, Illinois, the Midwest somewhere, or the East Coast or the Southwest, let us know too where you're listening from today, and then also the association that you're with in Arizona. Well, first I'd like to just start out by introducing myself. For those of you who may not have met me before, my name is Beth Mulcahy, and I am the managing partner of the Mulcahy Law Firm in Phoenix, Arizona. I also serve in the capacity of the senior counsel or senior attorney for our firm. And I've enjoyed representing homeowners associations and condominiums in the state of Arizona for the past 23 years. And my firm currently represents over 1,000 planned communities and condominiums throughout the state of Arizona. I also currently serve on my HOA board, and I have done so for many years. So I think I bring an interesting perspective to teaching these classes because not only do I have a lot of experience, over 20 years of working with many associations in Arizona, but I've also served on my board. And I have lots of war stories from representing associations and then also from serving on my own board. And we're going to talk a little bit about some of those interesting experiences and interesting personalities that we've dealt with really over the past 25 years. So I want to start out by saying that I hope that you and your family are staying safe and healthy. And I hope that your association is thriving in these difficult times of the COVID-19 pandemic, and that you're able to, be agile and adjust as things change. And I can just speak on behalf of my firm. I know that since March 15th, we have never worked harder than we've worked in the history of our firm, just staying up to date on all the new state and federal regulations and making sure that our clients' needs are being taken care of as these important questions arise pertaining to the pandemic. And if you had told us at the beginning of 2020 that this was going to be our year, I would not have believed you. But I like to think that things happen for a reason. And I think that, I've spent my entire career getting ready for this moment right now with associations and helping them navigate through these problems. So I want you to know that we're 100% in. We are here to help you, and we're here to give you good advice so that your associations can make good choices during these difficult times. So again, as people are joining us, it looks like we have about 38 people that are live and more are joining as each minute, now we're up to 40. Just like to know who's in my audience if you're joining us right now, and let me know where you're joining from or joining us today. And also let us know your association's name so I can see some of these names. And I'm seeing a lot of different people. Hi, Deborah. Hi, Holly. Great to have you watching. Hi, Bob. Good to see you. So what are we going to discuss today on this Facebook Live? We have a especially entertaining Facebook Live today. We're going to be giving you a quick update on COVID-19 and different things that you should be keeping on your radar with regard to that. And we're also going to be talking about 3D people. So people in your association who are difficult, disgruntled, and potentially dangerous. And so as part of our seminar today, we're going to be talking about experiences that I've had as legal counsel for associations and experiences that I've had as a board member for my association. and give you good advice so that you can help, navigate both the COVID-19 situation and also dealing with difficult owners. So let's start out with just the pandemic is not an excuse for bad behavior, but it's important for us to remember that this time is a extremely stressful and trying time for many people. Everybody is affected by the pandemic. And, sometimes when people are under great stress, we see the worst possible behavior. And so I think it is predictable that we are now dealing with some issues of difficult, dangerous, disgruntled owners. And, we've seen it before, of course, in working with associations for over 20 years. We've when there's a problem with a really difficult owner or difficult board member, I'm involved in that problem, helping the association, try to neutralize it and make the situation better. But we've seen more of that right now than ever. So I want you to know that if your association is dealing with this situation of a difficult owner, you are not alone. I've been receiving feedback from a number of clients that they've noticed an increase in the number of disgruntled owners, a rise in verbal altercations between owners because everybody is, a great majority of the people are still working from home, or maybe people are home because they've lost their jobs or they've been furloughed. We've also seen some physical fights where we've had owners get involved in fist fights on common areas of the association where the police have been called and criminal charges are being pressed. And unfortunately, all this uncertainty over the pandemic, coupled with civil unrest in our country, if you watch the news at night, every night for the past 50 plus days, we've been watching all the civil unrest in our country, has people on edge and tensions are high. And so I think this seminar is really timely today to give you some strategies to cope right now with owners and maybe even board members who are being difficult. And what are some strategies that we can implement to make the situation better? So we understand it's challenging right now in dealing with these type of people that are difficult, especially in today's climate when we're all dealing with our own challenges with the pandemic already. But we're here to help. So as always, during this Facebook Live session, I'm going to encourage you to ask questions in the comments section of this video. And I promise you, I'm going to save time at the end to answer as many questions as possible as I can. And if we do run out of time, I promise you, as always, I will answer any questions that are left in the comments section before the close of business today. So everybody will have their questions answered here live, which is my hope, or I will finish answering the questions that may come in the comments section that we don't get to right back in the comments section before the close of business today. I have a few questions for you, our viewers, so I can get a pulse on your current concerns before we get started. And it's great. I see we have 56 people now live watching us. And so I like to have interaction, even though I can't, see you raising your hand and waving at me in the audience or shaking your head because you don't like what I'm saying or agreeing with what I'm saying. I'd like to hear some feedback in the comments section because it helps me be a better presenter so that I know what your concerns are coming in today. And so first, tell me, what are some of your association's biggest concerns or largest concerns regarding the pandemic? Is there anything that you're worrying about? Should we reopened our common areas? Should we close them because things have gotten, more serious in Arizona right now? Another question that I would be interested in hearing is how many people have at least one disgruntled owner in your association? If you can say, I do, that would really help me to understand, if you have people that are disgruntled in your association, or just put a heart up on the screen if you want to send it, some sort of a message to me. I don't know if any of you saw the article in Sunday's Arizona Republic, but there was a really fascinating article on Sunday about short-term rentals. And this article was conveying that there were about 300 people having a party in a short-term rental in Paradise Valley recently, in the past week or so. And the article was talking about the need to regulate short-term rentals in an association, and the fact that the town of Paradise Valley was going to be taking actions on this. And I just would like to remind you that our firm has a wonderful cheat sheet on rentals and associations. That cheat sheet can be found on our webpage. And we also have a cheat sheet on amending association documents and implementing rental restrictions, which might be something that you may need to do if you are having a problem with short-term rentals in your association. And that cheat sheet will give you tips on what you can and can't do if you're thinking about putting together a rental restriction for your association. I'm seeing a question here about how to respond to an owner who wants to have a group at the community center for 25 people or less. We're going to be talking about that when we get into the COVID-19 a little bit more, but my feeling is that should not be allowed right now with the pandemic, and especially because the governor has renewed his order June 29th, talking about gatherings of people. But we'll get to that in a minute, Linda, so I promise we'll talk a little bit more about that. I see some people joining us from Tucson. Great, Poppy, thanks for being here today. And now we're up to 61 people. Okay, let's keep going. And as you join, I'm seeing one other thing. The pandemic is not our biggest issue. Our issue is whether to continue to allow rentals or not. And so, definitely take a look at our rentals cheat sheet, would be my suggestion. And, we give you suggestions on what you can and can't ask your renters for, or your owners for, the information about the renters. And we give you suggestions on how to deal with bad behavior by renters. And if you, want to do an amendment to prohibit short-term rentals or renters in general, or put time restrictions or minimum time restrictions, check out our cheat sheet on amending CC&Rs. Okay, one other kind of hot topic that we're seeing right now that I just want to mention at the top of this hour that we're going to be together are, we're getting a lot of questions about owners who are placing Black Lives Matter signs and flags on their property. And the question is that the associations have a restriction against these type of signs in their CC&Rs. And the Black Lives Matter flag is not a flag that is allowable under Arizona law as something that associations are required to allow to be flown on an owner's property. And so what's the best way to handle this? This is obviously a hot potato right now with all of the civil unrest in our country. And so let's just start out with a reminder as to what does Arizona law say about flags in Arizona. Remember that Arizona law mandates that associations must allow these following flags to be flown on an owner's property. So the American flag, the United States Army, Navy, Air Force, Marine Corps, or Coast Guard flags, those must all be flown consistent with the federal flag code. The POW MIA flag is allowable. Associations have to allow that flag to be flown. The Arizona state flag and the Arizona Indian Nations flag, and then finally the Gadsden flag. So there is no legislation that would allow an owner to fly a Black Lives Matter flag on their property within a HOA or a condominium. However, due to the civil unrest in our country right now, what we've been advising clients is we think that if your documents don't allow an owner to fly a flag of this nature, you want to check your documents for flag information. We still think that you should take a more relaxed approach on this and allow those flags to continue to fly for at least, the next 30 or 60 days. We definitely do not want you to be the association that is on the national news for not allowing this. And I think that, every association that we have suggested this to, it's worked out best. If you are going to send a violation letter to an owner for flying a flag or placing a sign like this on their property, I really urge you to check in with your legal counsel to talk through, what potential repercussions that may have for your association. The other thing that we've been getting a lot of questions on are owners that are gearing up for the November election and they are wanting to fly their presidential candidate flags. And we've received a number of questions on that over the past few weeks. And so, a few things on this that you need to know. Arizona law also talks about political signs, and it's in the Planned Communities Act and Condominium Act. And it says that the association shall not prohibit the indoor or outdoor display of a political sign by an association member on that member's property. However, the association may prohibit the display of political signs earlier than 71 days before the day of the election and later than 3 days after an election day. So what does this mean for associations? It means that owners can, fly a political flag or I think that would qualify under my interpretation of the statute, or fly a Trump flag or a Biden flag, or have a political sign on their property. But under the law, they can only put that flag or sign up, 71 days before the election, and then they must take it down 3 days after. So just know that is, where we are with that particular situation. Okay, I'm seeing a couple owner feedbacks here that you've got some 3D people. We're going to give you advice here to help you get through that. We've got some of our former board members that are causing trouble. That's very common, just so you know. And we'll talk a little bit about that as we get into our presentation. So let's get started first with our coronavirus update. In the last week, Arizona has now surpassed 160,000 coronavirus cases and 3,000 known deaths from COVID-19. And according to the Arizona Republic, public health experts have noted that the coronavirus outbreak in Arizona may be moderating. Officials warn, though, that more time is needed to see if this does, in fact, hold true. I think I read an article in the Arizona Republic this morning that was talking about the hospitalizations were starting to decline. So we're hoping to see, a more positive trend in terms of, lowering the number of deaths and lowering the number of new cases in Arizona. So what's happened since our last Facebook Live 2 weeks ago? Last Thursday, on July 23rd, Governor Ducey signed an order extending his June 29th, 2020 executive order for at least 2 additional weeks. And we'll know probably next week. We'll be putting out a lot of notifications on our Facebook and to our email contact list. If the governor further extends this or makes any other decisions, we'll be right there on social media letting you know. So what does this order extension mean that the governor issued last week? It means for at least the next 2 weeks, gyms and fitness centers or clubs must continue to remain closed, and pools that are located in HOAs and condos can stay open as long as there's signage posted at all entrances to the pool reminding people to maintain physical distance, and that groups of 10 should not congregate, and organized events of more than 50 people are prohibited even if social distancing is possible. So what's the bottom line for associations? You need to keep your gyms closed if you have one in your association. If you have a common area pool, you need to have signage posted reminding people to maintain a physical distance. In the pool area, groups larger than 10 should not congregate. And then there's kind of an additional caveat that says, public gatherings of more than 50 people are prohibited. So we had a question from a viewer at the beginning saying that somebody wants to use the common area clubhouse for a group that would be 25 or under. I really would advise against that right now. And I'm going to talk to you a little bit about a factoid on something that I can, explain to you why that's a bad idea. So hold on, Linda, and we'll give you a factoid on that will really help you here. So something for your association to think about is that the governor may extend the executive order next week. We'll just have to wait and see what he does. And again, we'll continue to monitor it and let you know what happens. And the link for the executive order has been pinned in the comments section of the video if you want to read the exact language of what the governor has extended. Something your association needs to start thinking about is it's possible that the governor may not renew this order next week. And so if you have a gym or a fitness center, your association needs to complete a form, a specific form that's provided to us by the state of Arizona prior to reopening the gym or the fitness center at your association. And so this form, we have a link for you that's going to be pinned in the comment section of this video. And you will need to fill out that form before you can reopen your gym. So you might want to start thinking ahead. If you have a gym in your association, get this form ready. I believe you can submit it, right now. If not, you'll be able to submit it as soon as the governor orders that the gyms can be reopened. But get ahead on this so that there's not a lot of stress, and start thinking again about your reopening plan. Remember that we have a cheat sheet on reopening of common areas, which we are posting in the comment section here to make sure you're going through the checklist of things that you need to do. And we have a specific section on gyms and health clubs. So make sure you're checking that out, and make sure you're filling that form or filing that form with the state of Arizona too. Here's just a cool little factoid that I want to share with you that a colleague of mine from Georgia sent to me earlier this week. And it's just fascinating to see all the cool stuff that's on the internet to help us make good decisions about coronavirus. And so Georgia Tech has created what they call an exposure calculator. And, what you can do is you can go to the link, and the link is going to be posted in the comments section of our Facebook Live here today. And basically what you do is you can click on which county you live in the entire United States. And they analyze the data of, what the COVID-19 infection rate is in your particular county. And then they give you probabilities of infection based upon the number of people that are attending events. And so we did a little check on this yesterday. We went into the Georgia Tech exposure calculator. And as of yesterday, in Maricopa County, if somebody attends an event with 100 people, they have a 99% risk factor of getting COVID-19. That's amazing, okay? If you lower the numbers to 50 people, you go to an event with 50 people, there's a 97% risk of being infected with COVID-19. If you have 25 people together gathering in Maricopa County, there's an 84% risk. These are just really incredible numbers. And then if you go to 10 people, which is about the size, let's face it, of most in-person board meetings, there's a 52% risk. And so, for those of you who are listening today, just remember that, we care about you, we care about your owners, we care about the associations in Arizona, and we want to make sure that everybody stays safe during the pandemic. And so it's a friendly reminder right now that our firm does not recommend that association hold in-person board meetings or in-person annual meetings or in-person meetings of the membership or town halls, anything like that at this time. Associations should be holding all meetings virtually for the foreseeable future. And if your board has not yet transitioned to having virtual board meetings, it's okay. You should start now, and we're here to help you. Your board meetings, your annual meetings, all should be conducted, via Zoom or any other online platform that you want to use to have a virtual board meeting, or even a conference call if you want to do it that way. We've noticed that we're hearing feedback from clients that they've just been waiting since March to do something, and probably violating the open meeting law if they haven't had any, open meetings. Now is the time to act, because it does not look like there is going to be an allowance to have in-person meetings here, probably through the end of 2020. And so now's the time to get up and running on virtual meetings. So for those of you who are dragging your feet or hoping that, we're going to have a miraculous, recovery here, and we're not going to have to deal with the pandemic for the second half of 2020, I'm here to tell you that you need to transition. And so what we can do to help you is, first, we have a cheat sheet, which we're posting in our comments section of this Facebook Live, on tips on running a virtual meeting. And we've been fine-tuning this for the past 3 months. It gives some excellent suggestions to all of you on how you can be successful and follow Arizona law running a virtual meeting, whether it's an annual meeting, board meeting, meeting of the membership. And so be sure you check that out. And then also, we're offering right now a special discount for any association in Arizona to hire our firm to help you with a virtual meeting boot camp. And we can structure that boot camp for whatever your needs are. If you want to have the board learn how to use Zoom, we will go hands-on with you and we'll train you on having a Zoom board meeting and share all the cool and unique features that you can use to run a successful board meeting or an annual meeting. If you want us to hop on and actually run the meeting for you and help you, assist you, guide you through that first meeting, we're here to help you too. So reach out to our firm and we'll get you set up with the virtual meeting boot camp. And there is a fee to do that, but right now it's a discounted fee. So if you're interested, we're here to help you. Please reach out to me at my email address, which we'll be posting in the comments feed here. Okay, so let's move on to the second topic today. And I have to tell you, gosh, we're up to 70 people watching. That's great. Thanks for being here today. For those of you who may just be joining us right now, I love talking about difficult people and harassment. But I have to tell you, as a board member myself, I have despised dealing with 3D people. So it's interesting that, when you're not so close to it, when you're the attorney for the association and you're guiding, you can certainly have a different feeling versus if you're the person that's being harassed as a board member, or you're having to deal day in and day out with a difficult board member or a difficult owner. And so I want you to know that if you're dealing with somebody like that right now in your association, whether it's a board member or an owner, I want you to know that I really do understand. I have, I'm going to tell you some stories today that will make you laugh, because if it's not you that it's happening to, you will think it's funny. But, and I'm sure you have stories like that too with the difficult owners. So, let's just get started and just dive right in and start talking about difficult personalities and how our associations can successfully navigate working with difficult personalities. First, let's start out with just a fact that I know is true. Every association has at least one difficult, dangerous, disgruntled homeowner in your association. That is just the statistics. Unless you have a very small association and you're lucky enough not to have one, this is something that every association has to deal with. And frankly, dealing with these 3D people is one of the reasons why people don't want to serve on the board, right? Or why people don't want to serve on the board for a long time, because it's frustrating, it's annoying, it's painful to have to go to meetings where there's a bunch of fighting and getting nasty emails at 2 a.m. It's not fun, right? And this is a volunteer job. So what my goal here today is to give you some tips on how to effectively navigate the difficult owner, to neutralize the situation as best possible. And so, let's just start out by, saying that national and local news have covered stories of disgruntled owners who act out violence in associations. Many, many years ago, I think probably 15 or 20 years ago, we had a shooting in Arizona where a disgruntled former owner came back to an association in the West Valley and shot and killed several board members. That's obviously the most extreme case that we've ever seen in Arizona. But every day we're hearing about problems in associations. At least our firm is receiving, questions from clients asking us for advice on difficult situations. So we have to be careful how we deal with these situations, and we have to know when to transition from somebody who's just difficult to somebody who's actually dangerous. And I think communication is key to, working on all of these situations and reaching out to your trusted advisors, your management company, your association's attorney. We are all here to help you, and recognize that I've had thousands of difficult people that we have dealt with over the years. And so we have, a good strategy and a good playbook for what works and what doesn't work with different owners. So let's start out with the fun topic of dealing with conflicts during a board meeting, right? So, I think the first baseline thing we should say is that name calling, interrupting, personal attacks in a board meeting, they should be prohibited and not allowed. at board meetings, committee meetings, annual meetings, removal meetings, special meetings of the membership. There needs to be, a baseline approach that, our meetings are not conducted in that manner. This is a business meeting. And if you have that problem, the president of the association needs to be the one to announce at the beginning of the meeting some meeting rules. And if your board needs suggestions on meeting rules, on how you can make sure that people behave properly at a meeting, make sure that you're reaching out to me, email me, and we can give you some sample rules that will help your association if you are having out of control meetings where you're having, screaming and yelling and name calling and bad language and bad behavior. So start out with, consider adopting meeting rules. So as a baseline, everybody knows what the expectations are for behavior at this professional business meeting. Okay, let's talk about when we have board member to board member conflict. I see this often, not as often as homeowner conflict at a board meeting, but we do at times see board member to board member conflict. And I'd like to start out by saying that it's okay for boards to have people that don't agree on everything, right? It's okay to have dissenters on a board, but it's not okay when the dissenters, are harming the association with their actions. So, for example, I've been a dissenter on my board, where I've served, where I may not vote for something. As a matter of fact, recently our association passed a rule that you cannot use skateboards on the common areas. And I get it. I really do understand where they're going with this, that they don't want, kids doing tricks on the railings and everything. But, I have kids too. I have a 12-year-old and a 13-year-old. And, my son responsibly rode his skateboard to school when we were, not in pandemic times. And he enjoyed doing that. And he wasn't, doing wheelies or doing tricks off the ramp. He was just riding through our association to get to school. And so when our association took the vote on this recently, I was the lone dissenter. And I got to tell you, when I left that meeting, I was mad. I was really mad about it because I was just thinking, this is ridiculous. We could have written into the rule no tricks, on, common areas and no ramping and all the crazy stuff that these kids are doing now. We didn't have to just take away that right. And I really did feel like the rule was directed towards kids. And, as the lone dissenter, there's the good Beth and then there's the bad Beth, right? The bad Beth was thinking, I think this is a fair housing issue. Should I cause problems on this, for my board? But then the good Beth got in check and she reminded me that, okay, don't be like that. Try to work with your board and talk to them about it. And I am doing that right now. I don't know if I'll win, but I am the lone dissenter. And I think that people can move from place to place in an association on a skateboard safely and not be dangerous to others. But so just know it's okay to have dissent like that. What's not okay would be, let's say that same scenario, where the board member leaves the meeting and then goes about causing a bunch of trouble. And we know how this works, right? The board member leaves the meeting and then they start spreading rumors, and the rumors are totally unrelated to what they're upset about, right? It could be, the board's thinking about a special assessment. They've mismanaged funds. We think, two employees of the association are having an improper relationship. The manager's getting kickbacks. That's the type of destructive things that, we sometimes do see board members do when they're getting outvoted on decisions. And so, what are some steps to limit board member conflict? So whether you're being outvoted or whether the board member is transitioning into now, basically making up things about your association, lying about your association to get attention or to make the board look bad. So here are some steps to limit board member conflict. Okay, number one, first, don't shut out board members. Give everybody an opportunity to contribute at board meetings. If you've got somebody who's long-winded, be sure to place a time restriction on everybody, not just the long-winded person, so that we can continue to move through the meeting. But telling people you can't talk, or, using bad language, telling them to shut their mouth, or we don't want to hear what you have to say, that's not how a business meeting should be conducted. Listen to everybody's point of view, okay? But place time restrictions so you don't get people who are, hijacking the meeting. Okay, the next thing is consider enacting regulations such as a time restriction or limit if you've got people that are going on and on and on about things. Allow follow-up discussion on a topic after all board members have been given the opportunity to speak. We attend a lot of board meetings, or I've attended, I don't even know, probably 10, 20, 30,000 meetings in the past few years, right? I have no idea how many board meetings I've attended, but one thing I've seen is sometimes when you have a real vocal board member who's in the minority on things in terms of voting, like maybe it's the vote's always, 5-2 that they lose, and they're in the 2. What we sometimes see is that one board member, when we're discussing before the board takes a formal vote on something, what will happen is, let's say board member 1 makes a comment, and then board member 2 is the disgruntled board member, then they want to make a comment. Then another board member makes a comment, and then board member wants to say something again. And so what's happening is that one board member 2, is trying to get in a word after every board member says something, and that can make your meetings really long, and it can make them, really argumentative too. So what we suggest is, if you're in that situation, have everybody on the board be given an opportunity to talk once before a board member would be given the opportunity to talk a second time. Educate new board members on board processes and outstanding issues. Sometimes when you get people that are new to the board, they need a mentor. So encourage mentoring of these new board members, explain to them, what the law is in Arizona, have them attend some of our seminars, get them up to speed on any litigation your association may have or any difficult situations, so that they see a 360 view of what it's like to be on the board. Even myself, when I've been on and off my board now a few times, in terms of, I took a little break when I started having kids for about a decade. Then I got back on in 2016. Even myself, when I was off the board and then got back on the board, I had some preconceived notions when I was just the homeowner about board issues. And I realized when I got on the board, hey, there's more to this story. And I didn't have all the facts when I was just a homeowner. And I really cut the board some slack on some things. So make sure that you're educating those new board members on different issues at your association, and making sure that if it's their first time serving on the board, that they feel comfortable explaining, Arizona laws, and giving them resources so that they feel like they can make good decisions as a board member. Okay. Let's see. What do we do if the behavior is just bad on a board member and it's creating conflicts within your board? And I have to tell you, this happened at my association where I live. And so I have some firsthand experience, and unfortunately it happened when I was the chair of our association last year, or the president of our association. And so I had a very trying year with one of our board members in our community. And, a few suggestions. So just to give you an idea of what we were dealing with at my association, and I've seen this repeat itself in many other associations, is this person became very disgruntled with the association and with the general manager, and started spreading false rumors regarding the manager and other employees of the association. This person was harassing other owners in the association. The person was harassing me, frankly. It really was a very trying time, because anytime this person would make a false statement about the association, 5 or 6 owners would contact me, and then I'd have to clear it up and give them the evidence to show that that information was incorrect. And it actually almost hit the breaking point where one of the employees of our association said that they were going to sue us if we didn't do something about this board member. So just know I've dealt with this. So here's some suggestions. If you have a board member that is creating a lot of issues And this isn't just dissenting on things. They have the right to dissent. This is creating true problems and issues in your association. Your board should consider adopting a code of conduct. And we have a cheat sheet on code of conducts for associations. And we give you sample language that you can use to help you through the situation. And we're going to be posting that cheat sheet in the comments section here, or you can find any of our cheat sheets on our firm's website, at mulcahylawfirm.com. And anyways, so consider the code of conduct, because that outlines what board members' responsibilities are and what is and is not acceptable behavior. And then just have your board vote on it at a regular board meeting. And what always happens with the people that are difficult as board members is they say, I'm not signing it. I'm not signing that. I don't agree to the code of conduct, and that's fine. I don't think you can expect them to, agree to sign something saying that they're, going to behave rationally and reasonably if they're really, truly difficult owner that's serving on the board. All you need is a majority of the board to adopt it. And I can tell you from firsthand experience, we had no trouble, working on adopting a code of conduct because everybody knew how serious the issues were with this one board member. So check out our cheat sheet. Adopting a code of conduct sets the standard for what is acceptable behavior and what is not acceptable behavior. And it also kind of starts to set things up if you ever have to remove a director from office. And we'll talk about that process here in a minute. So consider the code of conduct. Get advice from your attorney. We're here to help you. Your management company and your attorney are your trusted advisors. Maybe it's time to have our law firm come in and do a boot camp for your board. And one of the things that I do on boot camps that I think is really kind of fun, and boards love it, is we come in and we do a training session. And right now it's going to be by Zoom. And we talk about what are the problems in your association? Why are we having so much difficulty getting along as a board? And we have everybody take a personality test. And it really explains the differences between each one of us, because everybody brings a different personality type to the board. And it helps people better understand where people are coming from. Because let's face it, you can't change who you are. And if you're programmed, to be short with people, that's just how you operate. And, no matter how many times people, will ask you to be, maybe not as short with people or abrupt, those people can't help it. And so understanding each other's differences, and we use the DISC model, DISC, and we actually have a cheat sheet on this too, where it talks about what are the different personality types and how can you best work with the different personality types that we each have. And it's really, I've taught this class for many HOA academies, and it will give you good tips on how to deal with the person. And so if you go to our cheat sheet, you can find it on our webpage, and I think we're probably going to be posting it here in the comments section too. It tells you what are the different personality types, and we go through it in the boot camp, and we bring all the issues on the table, and we try to find common ground, and we try to find a way to work together. And we have been in any association that we've done the boot camp, everybody has walked away feeling better, and the problems have been lessened considerably, or they go away. So the boot camp's a great idea. To have a neutral person come in, our law firm does it, and help your association get through your problems. So some suggestions again on dealing with conflict with a board member or conflicts at a board meeting. Think about a code of conduct for your association. Check out our cheat sheet on that. Get advice from your attorney and your management company. Consider having a boot camp to resolve issues between your boards. Another thing that you could do is censure the board member for bad behavior. So if they're violating the code of conduct, that's definitely something that you as a board can do. You just need a majority vote, and it's basically just a censure on paper, but you're laying the foundation that this person is behaving improperly. Another thing that you can do is check your bylaws for your association. If the person that's problematic is an officer. You can strip them of their title typically, so the board can vote to take away the title of an officer. So if they're like the treasurer or the secretary, and there's a lot of issues with them in that position, the board, a majority of the board, typically, if it's in your bylaws, and it is in like 99% of the bylaws, can strip them of their title and then appoint somebody else to be that position as an officer, but you can't take away their right to be a director unless you follow Arizona law, which talks about removal of directors. And if you have to go that route, you'll want to check out our cheat sheet, the top 10 things you need to know about Arizona law. And number 6 on that cheat sheet talks about the removal process for a board member. And so I think, we've covered basically one last thing I'm going to say about board member conflicts. And this comment is actually going to apply to homeowner conflicts too, and difficult personalities in dealing with homeowners. The bully. If you have a owner who is a bully or a board member who is a bully, and this isn't every situation. This is like, it when you see it, right? This is like the person that is the most difficult bullying behavior. I'm going to tell you have to be firm with the bully. That is a time where you definitely need to get your legal counsel involved to help you navigate the bully. And I will tell you, as legal counsel for associations, I'm always looking for resolutions for associations. I'm not the type of person that is running to the courthouse to file lawsuits on things. We try to be reasonable and we try to work things out with associations and owners. But there are times when you're dealing with a bully that you have to be firm. And I'm telling you that when you're in that situation, sometimes you need to respond firmly, aggressively, right back at the bully, because that is the only language that they understand. And so making sure that you are getting good advice from your legal counsel and having them help you through this process may be the only way to deal with the bully. And I can tell you that our firm, unfortunately, we have a number of bullies that we're dealing with right now. We have a set process that we follow. It works. And I actually used it on our board member in our community, and it works. And so I think that that's a good suggestion. When you get the bully who's really giving everybody fits at your association, that's the best way to handle it. Get your legal counsel involved. Our firm's here to help you, and we will give you the secret formula to help you through with that situation. Okay, let's switch gears now and talk about the difficult owner. Maybe the owner that comes to the board meetings and is upset about things, or is writing poison pen letters, or is on Nextdoor, trash talking about the board or the association, or has a satellite Facebook page, Concerned Citizens of ABC Association. Or maybe they, put out flyers without their name on it, complaining about the association. So what's the typical difficult owner? What do they look like? They typically can be very outspoken regarding their view of the management of the association, whether it's the attorney, the management company, the board members individually, the finances of the association, how a project's going at the association. They love being outspoken about how finding faults in others, right? And so we have a nickname for them, and we got this from a CAI publication from many years ago. It's called a gadfly. And a gadfly is an expert at criticizing others, pinpointing the errors of others, demanding change, interrupting, attacking personal integrity, alleging conflicts of interest, just basically making people who, are board members or, management company representatives, making their life miserable, right? Because you have to spend a lot of time dealing with the gadfly, and it's stressful, and it's annoying after a while, having to always, defend yourself and put out the correct information when they're putting misinformation out into your community, or maybe they come to your board meetings and yell and scream and make false statements. This happens. This is common. So if you have somebody like this in your community, I'm sorry, but here's some good tips on how to deal with the gadfly. First, at the beginning of the meeting, you must announce, and this is every meeting, so this is just going to need to be a protocol for every meeting going forward. announce the meeting procedures at the beginning of the board meeting or meeting rules. Also put it in your newsletter or meeting notice. And if you want some sample rules, our firm, contact us and we'll provide them to you. But basically, you're going to pinpoint what behavior is problematic in the rules and then set up rules saying they can't do it. So no foul language, no talking out of turn, no screaming, no yelling. Treat others with different viewpoints with respect. There's a whole laundry list. And then enforce those meeting procedures uniformly. So what happens typically with the gadfly is they might be good for the first meeting when you announce the new rules. And then they kind of start to creep in and interrupt a few times at the next meeting. And then they start to escalate the behavior at the meeting after that. And I think it's important to be uniformly fair. And it's not just the gadfly. Everybody needs to be accountable to the meeting rules. And so when the gadfly tests you, and they will, make sure that you're nice but firm. This behavior is, in violation of the meeting procedures, of the meeting rules, and please stop. And if they do it again, then you need to either give another reminder that's more firm or ask them to leave the meeting. Sometimes if you have a really bad gadfly, the association is hiring a off-duty police officer to assist the association, to maintain control of the meeting. I hope that's not going to have to happen for your association, but it is an effective tool if you have a really erratic, difficult, disgruntled, dangerous owner. And so make sure you're establishing those meeting procedures, because if you have them and you don't set boundaries and limitations, they will test you and the meeting will be right back to being out of control. You may also, if it's a really bad situation, we've had associations hire our firm to come in and handle the meeting. And we, might come for 2 or 3 meetings until we get the gadfly or the difficult board member, back on track. And that's an effective tool too. Of course, that's going to be when it's, really out of control and the board can't use some of these tips effectively. We come in and help you do that. Another tip is have a homeowner forum at the beginning of the meeting so that anybody who's upset or angry or happy about something at your association can come in and say their piece. And typically that's about 5 or 10 minutes at the beginning of the meeting where owners are allowed to talk about any topic that they want to talk about. Remember that as owners complain about things or as they make statements during the homeowner forum, you want to be listening. You don't want to be checking your emails or your texts. Show them that you care and that you're listening to what they have to say. And then also recognize that you don't have to have a response for everything that everybody says. You just listen and say, we understand where you're coming from. Thank you for your comments. And if there's some follow-up information that the management company needs to give to them, make sure that, we do that. So if they say the management company doesn't return my phone calls and I'm frustrated because the sprinkler line right outside my home has been damaged for 2 months, make sure that your manager takes care of that. And, those board, we should be following up with the management company to make sure they're handling it so that that person doesn't get more angry or agitated. But remember, you don't have to answer everything. I know that when I was chair, we had some agitated homeowners who were upset about a 5-year plan that we were creating for our association to get ready for the future, and they were concerned that we were going to be spending too much money. And you don't have to. You just have to listen and say, well, I appreciate your comments, and we will definitely take that under consideration as we're navigating, this 5 years. You don't have to go point by point to each one of their questions. And if somebody's, really agitated, when I was chair, sometimes I would say, why don't you stay afterwards, after the meeting, and we can talk for a few minutes. And that way we can continue on with the business of our meeting. And I was surprised most of the time they didn't stay. Like they wanted to grandstand in front of the community. They didn't really want to talk with me about the issue after the meeting, which I thought was interesting when I was president of our association. Okay, establish control. Nobody should be allowed to interrupt board meetings by speaking out of turn, yelling, raising irrelevant issues, being disrespectful of anybody at the meeting. And the board president, that's really your job, is to make sure that your meeting is being run effectively, efficiently, and that there's control in the meeting. Remember that when you're dealing with a gadfly, do not argue with the gadfly. And this kind of goes back to the personality types of different people. So there's 4 different personality types, and 2 of the personality types like to argue. And so, if you're dealing with somebody that is one of those personality types that likes to argue, they love an argument, right? And so if you start to argue with them as a board member, they're loving it, right? It's like gas in their fuel tank. And so remember that you want to respond in a nice, non-argumentative voice. Try to de-escalate the situation. Do not, under any circumstances, respond with anger, argue, trade insults. And remember, you don't have to rebut the comments of any member. You can just do your best. If you have the information and it's quick to relay to them, you can do that, or you can get back to them later. Or if they say something that's just totally like left field, like we think the board's stealing money or there's a kickback here, you can politely correct that is not accurate, and you're welcome to check the books and records of the association, if you place a records request in writing to me. And I think those are all, good suggestions. Don't argue, because that's what they want. They want an argument. They're looking for a fight. Utilize parliamentary control. Know when to use Robert's Rules of Order. You don't have to use Robert's Rules of Order to run your meetings, but they are helpful. And here are some helpful tips that can help your association be more effective and maintain control and make your meetings a little faster. First, know when to table a motion. When you're going on and on and on and nobody can make a decision and you're really kind of unfocused in your motion, you might want to table it until next month so everybody has more time to think about it. Know when to refer a matter to a committee. I was on a board meeting last week where we were talking about, installing new air conditioning units in a condominium, and it was a pretty heated discussion and there were a lot of opposing viewpoints. And we just decided to refer it to a committee that can look into information. And we set up the guidelines to the committee, and the committee now is working on it. It's going to report back to the board. Limit debate. At a certain point, we need to move on in the meeting, and the president needs to be respectful, but you can't have these meetings last for 5-6 hours. A really effectively well-run board meeting should be 1 hour. And if you can do it in 45 minutes, A+ for you. But meetings that go on an hour and a half, 2 hours, 3 hours, there's some dysfunction, and you need to know when to limit debate. This is a business meeting, and it's not a social hour, so we've got to stay focused on the business of the meeting. Okay, what do we do if we have a really difficult situation, right? So our situation is, we're dealing with somebody who is, the uber difficult, right? So first, ask the difficult person to explain what the issue is. We do this at our firm often when we have somebody who contacts our office on a homeowner who's really upset about something in their association. We listen. We don't cut the person off. We listen to what they have to say. And so ask them to explain what they're upset about. Don't interrupt them. And listen carefully, because many times there's something that they've been wronged, and we need to apologize. There was a mistake that was made, maybe by the association or something, and so we need to listen to people and try to be helpful. And after the difficult person explains what they're upset about, agree with any truth in the complaint. Like, we agree that it's not acceptable that the sprinkler has not been fixed in 2 months, and we're really sorry about that. And we're going to get somebody out there right away to handle it. And, if the board made a minor mistake, acknowledge it. But refute an assertion that they may make, like the board doesn't know what they're doing or the board's misusing funds. You're going to have to, respond on something like that diplomatically. But if we have made a mistake, own it, be nice. And get it fixed and follow up with whoever made the mistake, whether it's a management company or the landscaper, and make it right. Make sure that they make it right too, in a quick manner. Sometimes after somebody really attacks the board at a meeting, and I had this when I was the chair, where I had this one gentleman who was really, really viciously mean to me as the board president. And it's okay to take a minute to compose yourself. And think about how you're going to respond. because a lot of things go through your head when someone is really vicious and mean to you as a board member. And I think you can be more tactful and businesslike if you let go of the emotions and the anger and calm down a little bit yourself. And so it's okay to take a breather, just take a minute and take a deep breath and say, then respond to that person. Offer to the difficult person what your best guess is as to how you're feeling. Like, I really do understand that you're frustrated about this. And if I were in your situation, I would be frustrated too. Ask them what they want. Oftentimes, they just want you to say, I'm sorry. I know just from being a board member, a disgruntled owner myself, I had a little stint as a disgruntled owner in my association, that no owner really wants to sue the association. No owner really wants to come to a Tuesday night board meeting at the library to complain about something, okay? So try to ask them what they want. What exactly do you want us to do? And say it in a polite way. How can we help you? What would make this a win-win? And once they tell you, what it is that they want, then see what we can do to help them. And see if it's possible that we can help them in that way. And then once the problem's been stated and understood, if you have an alternative as a board, offer it. Well, maybe we could do this. If you're fighting about something and the cost is, $1,500 and it's questionable as to who's in the wrong, the association or the owner, maybe you split the difference. Maybe that's a way to make this a win-win. And your attorney can help you because that's what we do for a living, right? We're here helping you resolve disputes. And we can tell you when it's a dispute that, hey, I don't think you should pay on this because there's no legal responsibility to do that, etc. And kind of one final point as we, end this discussion is, resist the urge to fight. Resist the urge to win every argument with owners. Listen, ask questions, be nice, be professional, be businesslike. This is going to lead everyone to the best solution for your association. Always having to be right and put people in their place doesn't make for kinder and gentler associations. Frankly, it makes for a lot of unrest and dissent in your association. So just try to be nice as a board, listen to people, look for solutions. And if the homeowner truly is wrong, don't stick it to them. Just say, hey, we had a little disagreement here. We had a misunderstanding. Let's all move forward. We're all neighbors. Let's try to work together. Okay, so let's talk a little bit about the last area, which is harassment. What do we do if it's true harassment? And how do we define harassment? So Arizona law defines harassment as a series of acts over a period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and that conduct in fact seriously harms, alarms, annoys, or harasses the person and serves no legitimate purpose. And that's outlined in Arizona Revised Statute Section 12-1809. So if you're interested in reading that, you can go to ARS 12-1809 on Google and you can read the entire statute on it. So how do you know when you have harassment? And it could be, harassment. I had it with my association where I had another board member who was actually harassing me in a time period of like 3 months. I think it was just under 3 months. This particular board member sent me over 200 emails. I mean, that is like ridiculous, right? And it was only meant to harass me as the board president. And it was annoying and it really was a problem. So what do we do if you have somebody like that who is harassing you, or even worse? I mean, we've seen situations where I had a board member once in Scottsdale who was cleaning some screens in his garage. And a disgruntled owner came up and tackled him from behind and, hit his head into the pavement. These are serious issues, right? And unfortunately, sometimes these are issues that we're seeing in an association. So, what can you do if you have a situation that's rising to that level? Well, the first step, tell whoever it is to stop. Tell them verbally. Keep a journal entry of all the different harassment that this person is doing of you or of any other. Note how you responded to it and keep all harassing emails. The second step is if the harassment doesn't stop, have the board or the management company or the attorney, if it's risen to that level, write to the owner in writing and tell them to stop, cease and desist from harassment, whatever the situation is. And state that you will be subject to legal action if this doesn't stop. And the third step is, going to court and getting an injunction prohibiting harassment. And there's a specific law in Arizona. It's in ARS section 12-1809. So ARS 12-1809. And if you are a board member who's on the receiving end of endless abusive telephone calls or who is regularly assaulted verbally in public by an angry owner, and there has been some sort of a threat of harm, like I'm going to get you, or you shouldn't go for walks at night, or something like that, you may want to seek, an order from the court prohibiting the bully from contacting you anymore. But I want you to know that courts do not issue these injunctions, without cause, and so they take these situations very seriously. And in most cases, the court will not give you an injunction prohibiting harassment against the other person unless it's a pattern of actions of harassment rather than isolated incidents. And the targeted individuals have to feel threatened by the action. And if you're dealing with actual physical threats, like if the owner, throws a punch at the meeting or pulls a gun on you or threatens bodily harm in a voicemail or an email, you should be calling the police immediately to document this, have the police come out and take a report. The police will also visit the harasser. And even if you don't think the threats are real, if they're putting it in writing or saying it to you, calling the police is a reasonable precaution, and it gives you a paper trail in case the matter escalates. Make sure they keep the police report on file, and that will strengthen your case if you eventually seek, an injunction against this person. And so just to kind of tie up the harassment part of this is if you feel that somebody is truly harassing you as a board member, the best way to handle it is to tell them to stop, number one. Document everything, make sure you're keeping a journal. Get your trusted advisors involved to help you navigate the situation. Maybe your attorney or your management company sends a letter to them telling them to stop. If it continues, or if you really do feel that you're in harm's way, you can go to your local judge court and you can ask for an injunction prohibiting harassment. You will have to meet with the judge, and a clerk will be there as a witness, and you'll have to tell, what the situation is, and you'll have to fill out some paperwork that they have forms there that you can fill out. The process, depending on how busy the court is, shouldn't take more than an hour. And you'll have to outline what behavior it is that is causing you to feel like there's potentially a threat of physical harm. But remember, you're likely not going to get one of those injunction prohibiting harassment unless there's a series of repeated acts that make you feel threatened, or unless there's actual physical contact with you, causing bodily harm to you, that type of thing. And of course, the harasser has an opportunity to have a hearing if they object to the injunction. And those hearings are always challenging, so you have to know that going in. You'll have to go to the hearing with the harasser, and you both, will be there, and you'll have to defend your position on why you should have an injunction. So make sure you're getting your legal counsel for your association involved if that is happening, for your association, because it's important that, you have adequate legal representation to help you through that process. Okay, so now we're nearing the end of our discussion today, and I see some questions here, so we're going to spend a few minutes going through as many questions as we can. I'm sorry I'm a little bit over on the time, but this is just a really important topic, and I know a lot of associations have questions on this, so I want to make sure we cover it. So the first one is from Steve. Although we don't have an issue with Black Lives Matter flags, we must remember that such flags are protected under the First Amendment. So HOAs need to be very careful about how they determine which flags can be flown and which cannot. I couldn't agree more. That's why I suggested that associations be very cautious if you have that situation right now, and talk with your legal counsel about the best way to handle it. From Rick, delinquency question. Our HOA has an assessment collection policy stating delinquent owners will receive a courtesy letter when 15 days late, a demand letter when 45 days late, and a lien at 90 days. At what point should our HOA bring you into the picture? I would say after the lien is recorded, if you feel comfortable recording the lien, or if you, after the 45 days late, you could turn it over to our law firm. At that point, we can help you with the lien. If they're only 45 or 60 days late, we'll start out with a letter to the owner. That'll be our first thing that we'll send, and then we'd probably send a lien afterwards. But Rick, remember that the law changed in Arizona last year, and there's some specific language you have to have in your letter when you send out that 45 days late letter. And so you want to make sure you contact our office to get a sample of the language that you have to have in there. But the bottom line is you have to tell the owner that the file is going to be turned over to the attorney and give them, I believe it's 30 days before you can actually turn the file over to our firm. So if you want that sample letter, anybody on this call here today, this Facebook Live, you are welcome to email me, and we'll be sure to get you that sample letter. But you have to have that letter sent before you can turn it over to our firm. Okay, do we have to enforce the pool restrictions? What about groups of 10? So really difficult in the pandemic right now. Do we have to be the pool police? And if we see people congregating without face masks, and somebody brings in a party of 15 people, what are we supposed to be down there with our clipboards? This is a difficult question. You need to have signage posted at the gates of your pool, and go to our cheat sheet on reopening common areas. We have some great sample language that you can put in there. And remember, the governor has the new rule that talks about you shouldn't have more than 10 people congregating in the pool area. You could send letters for your association, but you can contact the police, although I know the police right now is extremely busy. But hiring a security guard to be down there to keep track of the goings on at the pool so that people don't violate the large gathering thing. I mean, associations don't have the budget for that. So I would say my suggestion is have the signage posted, send follow-up letters if there are people that are offending or are not complying with the law on this, and contact the police in extreme situations, especially if it's a huge party. Okay, so do we have to enforce it? I would say you should try your best, but you don't have to enforce it by hiring a security guard to do that. Patricia is asking, can more than 10 people be at the pool as long as no more than 10 congregate in a group together? My opinion is yes. So if you have a pool area that is large enough to accommodate 10 different people and they're able to socially distant, that's fine. 4 people around a table, I don't have any objections to that. Obviously our signage at the pool is going to say enter at your own risk. How many chairs can we have out at the pool? You're going to have to factor in social distancing. Some associations are leaving, all their equipment in there because they have no other place to put it. Some associations are removing, half of it or more. It's really up to you how you want to handle that. Shauna, good to see you, one of my managers that I work with. What are your recommendations to an association who may be considering holding drive-in movie night in place of a social gathering in an open space? What a good idea. That's so fun. I'm not opposed to that at all. You want to make sure that you have all the licensing requirements for a movie if you're going to be doing a movie replay. So you may want to contact our office to help you with that. You don't want to rebroadcast a movie without having, paid the necessary fees. You don't want to get in trouble for that. But as long as there's social distancing and you have a location where you can have a drive-in movie at your association, how fun is that idea? I wish our association would be able to do that. Mark, when we resume in-person board meetings, can we legally prohibit firearms? Ooh, that's a hot topic, right? Mark, you're making me think at the end of my seminar. I think you have to look at where you're having the meeting. Many, locations in don't allow to have a firearm at the meeting. And so if you're having it at like a library or a church, they may already have that rule in place. If you're having it at the management company, as most management companies also have that same rule, so private location. So it really depends on your location of where you're having it. Obviously in Arizona, there are more freedoms with regard to carrying, concealed weapons. But if you're having it in a private location, whoever is the person that is, in charge of making rules for that location, they certainly can make their own rules. So as we get back into in-person meetings, if you want to reach back out to me, I can give you some good advice once I know where your meetings are. Corin, we'd like to issue a required acknowledgement that residents need to sign in order to receive the new pool entry key card. The acknowledgement would cover pool rules and any updates required by the health department. There's concern that a few of the agitated residents won't sign it. Can we withhold the pool key card until they sign the pool rule acknowledgement? I would shy away from not allowing them to use the pool, just because they won't sign the acknowledgement. What you could do is you could, just provide them with a copy of it and then have them sign that they received a copy of it. That would be one way to handle it. If you're going to formalize the rules into formal rules for the pool, and one of the formal rules is that you have to sign this, that's a possibility that you could make it mandatory, but I'm really kind of shying away from that. I think that's going to create a lot of unnecessary hassles for you. What you could just do is have them acknowledge that they received the pool rules and, leave it at that. Okay, we're kind of running out of time, so I'm just going to do a few more questions here, and then I promise we'll answer the rest of the questions in the comments section later today. Let's see. On Zoom, the meeting host can mute the homeowners and just allow the board to speak. So can you do that? Yes, they can. I've been on different Zoom calls, obviously, since March, and the larger the meeting, the more important it is that the meeting host be able to mute people. Remember, though, that owners have a right to contribute at appropriate times during the meeting, and that would be before the board takes formal action on an item. So when the board's voting, after the board discusses it, before they take the vote, the owners should be allowed to participate if they want to. But muting the owners is something that I think most associations are doing just because of the noise and the background noise. So I don't have any issues with that, but just remember that if an owner wants to talk, make sure that you're saying that they can raise their hand in Zoom, and they can do that through the feature right on the Zoom screen, and then you can open it up and have the homeowners talk, and a reasonable number of homeowners should be able to talk on each side of the issue before the board takes a vote. How to respond to, and you can put a time limit on them too, just so the meeting doesn't get really long. How should we respond to a request to use, okay, I already answered that one, Linda, I got that already. Barbara, is the board violating the rules against open meeting laws if the board members discuss issues over emails, such as giving opinions on issues to reach a decision? Well, it's not advised, I'm sure, but the facts are needed before making decisions. Okay, Barbara, good question. Yes, if your board is discussing items and it's a majority of the board and you're doing like a reply all feature, you are violating the open meeting law if you are discussing things and voting on things via email. The only exception to that would be is if there's a true emergency and you have to make a decision quickly, then you can make decisions, by email using the emergency function. But use that sparingly. It's only if you can't wait 48 hours to notice a meeting, and it really does need to be an emergency situation so you don't get sued for violating the open meeting law. Any new laws passed this year? Kim is asking me regarding HOA life. No, this is like one of the first years since 1995 when I started practicing law that there were no new HOA or condominium laws. And so, this was an unusual year. The legislature passed a skinny budget. There were lots of HOA bills introduced this year, but none of them passed because the legislature adjourned early. We thought the legislature may come back in the summertime to, reconvene, but that hasn't happened yet. So right now we're footloose and fancy-free with no new laws this year for condominiums and homeowners associations. Let's see, last question will be, are there any issues brought about by the pandemic that will need to be considered in future updates of our association's CC&Rs? Wow, Stephen, what a great, thoughtful question. I love this question. So yes, there probably are, like the ability to have virtual board meetings or, many of the other things that we've adopted here today. But I think it's too early to consider what those final rules should be. So I would say, towards the end of this year, we can start thinking about what would be some new normals that would make things significantly easier to operate our associations as a result of the pandemic. Is there any initiative for the Arizona legislature to exempt nonprofit HOAs from pandemic liabilities? Okay, really good question. There was a bill that was introduced, I think it was by the House or maybe it was the Senate, just one chamber had introduced a bill. They reconvened, I think it was the House, they reconvened shortly, I can't remember, it was in April or May. And they introduced a bill, but it didn't move anywhere in the Senate. And so right now we don't have it. But if there are a number of other states that have implemented rules like that, and if you've been watching what's happening on the federal government, there was a bill introduced yesterday as part of the Relief Acts. So I think we can anticipate that we're going to see something like that to get America back on track again. And I really hope that, it's probably not going to be HOA specific, of course, it's going to be any business. But we'll just have to continue to watch that, and we'll make sure we address that on our future Facebook Lives. So that's a really good question to end on. It looks like I have a few more, and I promise you, Gina, Patricia, Nancy, Steve, and John, I'm going to make sure that I respond to your questions before the close of business today in the comments section. So I'm sorry that I couldn't personally answer it on Facebook Live today, but I'm already 20 minutes over into overtime, and I want to make sure that everybody can get back to what they were doing this afternoon. So I'll be sure to respond to those this afternoon. And I just want to, in closing, thank everybody for being here with us today. It's been wonderful to be able to connect with you on Facebook Live, even though I can't meet with you in person. And I'm very appreciative that so many of you care about your associations and are willing to be here today. I think at one point in the call, we had over 70 people who were on the call wanting to learn about, the topics that we're discussing today. Just a few quick reminders. Our next First Friday free call-in is August 7th. Board members and managers are welcome to call our firm between 9 and 10 a.m. at 602-241-1093 on the first Friday of the month, which is going to be Friday, August 7th is the next one. And you can have a Mulcahy attorney answer a community association question free of charge. We do ask that only one person from your board call us with the one question. And we'll be back on Facebook Live again in August, same time, same place. August 18th and August 25th, we have 2 more classes that we're going to be talking about, and each one will have an element of an update on the COVID-19. And we've selected 2 other topics. If you go to our webpage, we have those topics listed under our seminars tab. And in the meantime, if anything happens, the governor, has any new orders or any new restrictions that apply to associations, I can guarantee we're going to be talking about it on Facebook and through our memos via email. So we'll be in touch with you, and if need be, we'll go live before our next seminar on August 18th and August 25th. So I encourage you to stay in contact with us, keep checking our Facebook page, and I hope everybody stays safe and healthy during these difficult times, and know that we're here for you. If your association has any questions, please reach out to us, and we will do our very best to help you through any problems that you're having. I hope everybody has a great rest of the week, and I look forward to the next Facebook Live on August 18th. Take care, everybody.